Next paragraph. While some have cited this order as authority for the federal usage, the Health, Education, and Welfare Report find otherwise nothing. It has been suggested that Executive Order 9397 was intended to apply only to instances when federal agencies seek to number records such as employment, attendance, performance, or medical records. To interpret the order as applying to all kinds of federal agency record systems is arguably beyond the meaning of its language. In any case, it appears that federal agencies were free to use the Social Security number in any way they wished, and no instance has come to our attention in which the order has been invoked to compel or limit any agency's use of the Social Security number. The Health, Education, and Welfare Secretary Committee came to the following conclusions about the need for legislation in this matter. If the Social Security number is to be stopped from being the de facto standard universal identifier, the individual must have the option not to disclose his number unless required to do so by federal government for legitimate federal program purposes, and there must be legal authority for his refusal. Since existing law offers no such clear authority, we recommend specific preemptive federal legislation providing that the individual has the right to refuse to disclose his Social Security number to any person or organization that does not have specific authority provided by federal statute to request it. That refers to Section 2B of the Privacy Act annotation, and the right to redress if his lawful refusal to disclose his Social Security number results in the denial of a benefit. That covers in Section 7B of the annotation. Now, we're going to look at subsection under Public Law 93-579 on page 6982. It states, provides that no person may condition the granting or withholding of any right, benefit, or privilege, or make as a condition of employment. Yes, that's what I said, employment. The securing by any individual of any information which may be obtained through the exercise of any right secured under the provisions of Section 201. It reflects the Committee's intention to protect the data subject from coercion by government agency or private businesses and organizations who may condition rights, privileges, benefits, or considerations otherwise due a person equally with all other citizens upon the obtaining of a personal file or data. This subsection reflects the concerns of administration and agency spokesmen who feared that opening up the individual's personal files, which have been protected from disclosure to that person or to others in society, would subject a person to all kinds of demands for medical and other personal records. Since the Committee's intent is to make certain inroads into the well-maintaining partisanship of federal agencies, so that an individual may be advised what information the agency is collecting or holding, this subsection provides the right against such coercion, which is enforceable in the federal district court in a civil action pursuant to Section 303C. This subsection is not intended to prevent an individual from seeking or obtaining rights under Section 201, but is designed to provide a legal remedy for what is believed to be unreasonable and coercive pressures on that person sufficient to state a cause of action before a federal judge.
Do we have a deal, Mr. Reagan?
You know, I know this stake doesn't exist. I know that when I put it in my mouth, the matrix is telling my brain that it is juicy and delicious. After 9 years, you know what I realize? Ignorance is bliss.
Then we have a deal.
Neo, no one has ever done anything like this.
That's why it's going to work.
Would you please remove any metallic items you're carrying? Keys, loose change? Holy shit! Ugh.
Back up! Stand back up!
To write this annotation as an indexing reference, since it is not codified like other statutes in the United States codes, you will need to write this as a statute at large. Whenever you are requested to disclose your Social Security number on any kind of application, either for employment, credit, banking, financial, governmental, whatever it may be, you will need to break the sections down so that any corporate attorney or any attorney at all, be it a paralegal, whatever, can understand what it is you've written, so that in case your argument of not disclosing your Social Security number happens to go to federal court, you will be in a better position since you have fully disclosed on the application your statutory rights of non-disclosure. It will be written as the Privacy Act of 1974, 88 Statute 1909, 7A1, 2A, 2B, 7B. Now, upper and lower cased letters are very important when you write this out on any application. The reason being is because if you put a capital A where the 7 is, it will not make any sense, and you'll get thrown out of court on a technicality because you were not explicit in the exercise of your statutory right. Now, these applications that you're seeing here are on previous applications to give you an example of hypothetical disclosure of how it's supposed to be written. If you notice that I left out the section 2A and 2B, and I have since reformulated the tactic used by putting those in that section. You will have to write really small because they don't give you a whole lot of room to put that whole annotation in there. I have won previous arguments by doing that, but I have come to the conclusion you need to write the entire annotation in the square or the block of where they've asked you for your Social Security number on any type of application.